Attorneys from the Bryant Law Center are our guests today on Local 6 Legal Line. Joe Roark here in the middle, Kevin Shannon to my far left, answering your questions about divorce and personal injury. And I think we're going to focus on divorce for this first segment. They'll be back here in a little bit to talk about personal injury. But give us a call, 1-888-208-6946. And we do have a question already from Bree, who says, when filing for divorce, what are some things I need to be careful about?
Okay, well, when you're filing for divorce, something that you would want to be careful about would be kind of how you're managing your finances and making sure you don't do anything that could be construed as sort of spending a lot of money or incurring a lot of debt right before you're about to file. It is likely those things would kind of be assumed to still be there, and you'd have to account for all of that spending. Otherwise, what you'd want to do is just see if you can have a pretty good handle on the kind of general state of your marital finances, such that you know what accounts you have, what debts you have, what sorts of retirement accounts are out there, just so you have some guidance that you can give to the attorney, and so you know what it is that would be subject to division at the time of your divorce.
We have another question from Harold, who asks whether the money in a joint bank account goes to him or his estranged wife.
Well, if you go through a divorce, the law says that there is a presumption that everything that was acquired during the course of your marriage is subject to division at the time of divorce, subject to a couple exceptions. And so if that money in that joint bank account, even if you're estranged, is still theoretically marital in nature as long as you're married. So when you say I do, that has some legal consequences until you say I don't. So even though you're estranged and separated, that money could very much be subject to division. Now, depending on the particular facts and circumstances, how long it's been and what the source of the funds were, you can make some equitable arguments that it shouldn't be divided. But as baseline proposition, we start with the presumption that money is probably subject to division.
Carla says, my husband wants us to use the same attorney. Is that really a good idea?
Well, oftentimes it can create some problems. If you have an agreement, that is the only time that the parties only need one attorney. And when you say use the same attorney, people need to understand that one attorney cannot represent both parties in a divorce action. That attorney only represents one of you, and therefore only has some ethical obligations to make sure that the person they represent is getting kind of the fair shake. But if you have an agreement, you're not under an obligation to have any sort of attorney on your own. But just understand that if your soon-to-be ex-spouse is the one that hired the attorney, that attorney represents them and not you. So you might want to let somebody look at it on your own for your sake.
We have a question from Judy, who wants to know what Kentucky law says about child support payments when ex-spouses have 50-50 parenting time.
Yeah, in that circumstance, what is usually done is that you would run a normal child support calculation as if the husband had the kids primarily, and then you run another child support calculation as if the mother had or the wife had the kids primarily, and then you take the difference between those two figures, and that is how courts offset child support in a 50-50 time-sharing arrangement. It doesn't do anything to the percentages usually of extracurricular activities or extraordinary medical expenses or work-related daycare or health insurance costs, things like that. But typically what you do is you just run it both ways and take the difference between the two figures.
Mark says he's got a problem. His wife changed all the locks on the house after they separated. Is she allowed to do that?
Okay, that is also something that depends on the facts and circumstances of the particular time. If she just did it one day and you were living in the house and then you came home one day and all locks were changed, I think that is your home and you're entitled to re-enter it. But if you find yourself in a circumstance like that, it is usually a sensible proposition, you know, if you're going through a divorce, to get an order for an organized time. To the extent that that's possible, don't just go kick the door in, even though you're entitled to have possession of that house until it's been determined. Don't do anything rash that's going to get you charged with a crime or an emergency protective order, anything like that. Just try and act sensibly.
Act sensibly is the key thing right there.
Yeah, and that you're not in the best stage of your life to be acting real sensibly, but do the best you can.
All right. Joe Roark and Kevin Shannon have been our guests on this version of Legal Line. Kevin's going to get his turn when we talk about personal injury coming up here in about 25 minutes.